You've built wealth over decades, a business, real estate, investments, a strong portfolio, and then one day a storm hits. You're not in love anymore. Your spouse isn't either. But now it's not just emotional, it's financial. Your retirement, your legacy, even your future income is suddenly on the line. And here's the question that haunts so many successful people. What could I have done before this happened? Let me show you. Hi, I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been protecting people's assets for over 34 years, and for nearly 30 of those, I've been setting up the Cook Islands Trust, arguably the most powerful legal tool on the planet when it comes to protecting wealth from lawsuits, legal sneak attacks, and yes, divorce. And this video is going to give you what most attorneys won't or can't, because I'm not here to tell you how to get through a divorce. I'm here to show you how to protect yourself before one. So if you're serious about protecting what you've built, click that subscribe button if you haven't already, and let's dive in. Let's get real. In the US, nearly 50% of marriages end in divorce. And for high net worth individuals, it's not just a split, it's a financial bloodbath. Here's what's at stake. Equitable distribution. In most states, that means 50-50 whether or not your spouse contributed financially. Alimony, potentially for life, depending on the state. Future income. Judges have discretion to award a piece of your future earnings. Business interests. Your company could be forced into a valuation and division process that cripples operations. In fact, one case I saw, a business owner had a $12 million company. His spouse's attorneys hired a valuation expert who priced the business at $18 million, completely ignoring liabilities. The court agreed he had to buy out his ex at a price that nearly killed the business. So here's the catch. Many people try to protect their assets after they see divorce is on the horizon, and that's too late. And let me explain why. In this section, I'll explain why timing is everything and the legal wall that stops you. So let's say you move your assets into a trust, an LLC, or a new account after divorce papers are filed. Sounds smart, right? Wrong, and here's why. The court likely issues a financial restraining order the minute the divorce starts. That means there's no selling, transferring, hiding, or moving assets, especially anything material. And if you do, you're in violation. That's contempt of court, and you could lose credibility and be forced to undo everything. But even before the papers are filed, here's another legal issue: fraudulent transfer laws. And no, that doesn't mean you're committing fraud. A fraudulent conveyance is a civil term, and it simply means that you transferred assets with the intent to keep them away from a future creditor, or in this case, a divorcing spouse. Now, in some states, the look-back period on fraudulent transfers is up to 7 years. In others, it's shorter, but still enough to drag you into legal hot water if your setup looks suspicious or is poorly timed. So how do the wealthy legally protect their assets before divorce? They plan ahead using bulletproof legal tools, and this is where it gets powerful. First, we'll talk about domestic tools, limited but useful when done early. So before we get to the offshore bombshell, let's quickly cover the domestic options and why they're usually not enough on their own. First of all, prenuptial and postnuptial agreements. Now, prenups can work sometimes, but they must be, 1, written correctly, 2, signed well before the wedding, and 3, disclosed fully and fairly, and not what we call unconscionable. And even then, we see them challenged up to 80% of the times in divorce, many times successfully casting them aside. Now, postnups are even trickier. Courts scrutinize them intensely. If your spouse was pressured or not properly advised, it's toast. Next, domestic asset protection trusts. Now, some states like Nevada and South Dakota allow self-settled trusts that claim to protect your assets. But guess what? If you live in a non-DAPT state, one that doesn't have domestic asset protection trust laws, or if your spouse sues you in your local court, judges often pierce them. So that's why I tell clients this: DAPTs are good for making your assets harder to reach, but not impossible, especially in divorce. Okay, now let's talk about what the ultra-wealthy actually use. We'll call this the offshore fortress and how the smart protectors do it. So this is the asset protection equivalent of a steel vault buried in the Mariana Trench. Cook Islands Trust with a Cook Islands LLC, and the same combination in Belize works well also. So here's the structure we've perfected at Asset Protection Planners. We've set up Cook Islands Trust, a legal structure in a jurisdiction that doesn't recognize U.S. judgments. So inside that trust, we create a Cook Islands LLC, and we make you the manager of that LLC. So you're the signatory in the bank accounts, you can do your stock trades and so on. So you transfer ownership of your non-real estate assets, we'll get to real estate in a moment, cash, crypto, brokerage accounts into the LLC. That's where we hold the bank account in the LLC, and the LLC is owned 100% by the trust. It's 100% member of the trust. In other words, the trust holds 100% of the membership interest in the LLC. So here's the secret sauce. You retain full control while the waters are calm. But if a legal threat arises, like a divorce, our licensed bonded trustee company law firm steps in to protect the trust and its contents. At that point, U.S. courts can't force the trustee company to comply. U.S. courts have no jurisdiction there. And here's what that means in practice. If your ex's attorney demands the assets, you say, I'm not the legal owner, the trust owns them. And now it's your trust. And there's not a judge in the U.S. who can force the Cook Islands to release them. And if they try to sue the trust directly, they must file the lawsuit in the Cook Islands, where contingency fees are not allowed, where the loser pays the legal fees, where no judge has ever overturned a properly structured trust that we've created. And here's the kicker. You might be wondering, but isn't moving assets into a Cook Islands trust still a fraudulent transfer if divorce is on the horizon? We'll get to that, and the answer might surprise you. At first, a quick example from the field. We had a client, let's call him James. James was a tech entrepreneur in his early 40s, built a SaaS company from the ground up. He had about $15 million in assets, most of it in stock, some real estate. He came to us for a Cook Islands trust, not because he was getting divorced, but because he might be in the future. His marriage was rocky, so we set up a trust, moved his brokerage account and crypto into the Cook Islands LLC that's inside the trust, and did a domestic equity strip on his U.S. real estate. So that's how we do real estate, equity stripping. Now, 1 year later, his wife filed for divorce. Her lawyer tried to claim that James hid assets overseas, but James disclosed the trust in his financial affidavit, including the year it was created, before any divorce filing or restraining order. So guess what? The judge ruled that the trust was valid, pre-existing, and not part of the marital estate. James walked away with his business, his trust intact, and 90% of his net worth untouched. Okay, as promised, the fraudulent transfer question answered. So now back to our earlier cliffhanger. What if your spouse argues that the trust was a fraudulent transfer? Now, that depends entirely on when and how you set it up. If you create the trust before any divorce is discussed, with clean documentation, with fair treatment of the marital estate, it's not a fraudulent transfer, it's asset protection. But if you set it up after separation, transfer everything out of reach, or hide the trust entirely, you're walking into legal landmines. And that's why our process includes legal memos, documentation, and detailed asset lists. So we make sure that you're not breaking rules. You're following them strategically. Okay, now let's talk about real estate in divorce and why you don't offshore your house. Many people ask, can I put my home in the Cook Islands Trust? Well, not directly. Real estate is governed by the laws of the state where it sits. A Florida judge can still order a transfer or for sale because it's within his jurisdiction. But here's the workaround. We use equity stripping, and here's how. You set up a Wyoming LLC that owns a mortgage recorded against your home, and that mortgage is then assigned to the Cook Islands LLC, and then if divorce strikes, it looks like the property has no equity. The mortgage eats it up. So we need to bring in a third-party lender to buy the note and deposit the cash offshore so you're fully protected when the legal bullets start to fly. Now, the value is no longer in the house, it's in the offshore trust. And that's the difference between owning real estate and controlling it safely. Now, here's some common mistakes people make. Let's bullet these out. First of all, waiting until divorce is likely before doing anything. So thinking a domestic trust will hold up against a determined divorce attorney, you can forget about it. It's not. Using your local estate planning attorney who's never touched offshore work, that's another mistake, and believing that being transparent means being unprotected. Keep in mind, hiding doesn't work. So remember, transparency doesn't mean vulnerability. With the right structure, you can disclose your trust and still keep your assets safe. You don't need to hide your assets as long as they're structured properly. Okay, now let's talk about timing, ethics, and the asset protection lifestyle. Now, this isn't about hiding money. It's about legally and ethically protecting what you have earned. When done right and early, asset protection looks like planning, not panic. The wealthy do it quietly, proactively, and smart. You don't wait until the rain starts to buy an umbrella. You buy it when the sun is still shining. So here's your takeaway. If you're in a rocky marriage, or if you're not married yet, but you're thinking about it, or if you just want to protect your legacy no matter what happens, this is your window right now to do something about it. At Lawyers Limited and Asset Protection Planners, we've set up more Cook Islands trusts than anybody in the world, and it's the strongest legal tool out there to protect assets from divorce. Our clients include business owners, physicians, real estate moguls, tech entrepreneurs, you name it. We've seen the financial records of divorce up close. We've helped thousands walk away protected, empowered, and ready for the next chapter. So if you're ready to put a plan in place before the storm hits, you can feel free to visit us. A lot of free information at assetprotectionplanners.com. You can call us at 954-400-1050. Because when it comes to divorce, it's not about reacting later. It's about protecting now.